Hey up there, legal warriors. I've been asked to make this video about what the best possible domestic violence defenses might be if you're charged or accused of domestic violence in Washington state. If you're interested in criminal law, stay tuned. This video is for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years. And I'm putting out these videos to educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. And that's just going to jump right into it. None of us wants any domestic violence to happen. I'm a defense attorney, and so I see lots and lots of cases that involve domestic violence. Some serious, most hopefully less serious squabbles at home that lead to somebody getting arrested. And I've been asked by so many different clients over the years to go, hey, what are the best defenses to a domestic violence case? Because there's usually two sides to the story, right? It's not always exactly like we imagine where it's just a one-sided story. So while I don't condone domestic violence, we try to defend anybody charged with a crime and try to better themselves. I'm going to jump into what are some of the best defenses to a domestic violence charge? I think there's basically three categories, okay? One is it didn't happen. Two is it didn't happen like that. Or three is something happened, but it happened because I was defending myself. I think those are the three basic factual type defenses. And when most people think, how do we defend, what's the best defense for a DV case, most people out there in public think, what's a factual defense? And I think one, two, or three, those three options need to be combined with other things to get the best possible result in a case. But let's just start with one, two, and three. One, it didn't happen. Well, what I mean by that is, hey, I wasn't there. It didn't happen like this person said it happened, right? My husband of a woman, my husband said that I came home and I punched the door and put my hand through it, domestic violence, malicious mischief, that would be. And it didn't happen because that hole was already there. I wasn't even home. He was drunk, and he's just getting back at me because I was out too late, right? That's one defense. Just factually, it didn't happen. There's nothing that's even close to that is what happened. And so that's one factual defense we can use. It simply didn't happen. Seems simple, but it's not always so simple. Moving on to number two, it didn't happen like that. Well, let's use this same example, a hole in a door. So it's a crime to maliciously and knowingly damage property of another. If we're married, then half that door's mine and half that door's yours. And the police get called and the husband is saying, she punched a hole in the door because she wanted to get at me in the bathroom. And let's say there's a hole in the door, and let's say the wife did cause the hole, but maybe it didn't happen like that. Maybe it was an accident that it got damaged. Maybe she tripped and put her arm or her hand through, damaged the door in some way. These are just hypotheticals and coming up with on the fly. So it didn't happen like that means yes, something happened, but the red mark on the person wasn't caused by me slapping them. It was caused because they were upset, and they always flush when they get red. So something happened, but not like that. Is another type of factual defense. And I think the third defense is, yes, something happened, but it was self-defense. Okay, self-defense. What do we mean by self-defense? Well, in Washington state, we're allowed to use reasonable and proportional force to defend ourselves from someone attacking or assaulting us, right? To defend ourselves, to defend our property, that type of stuff. So if someone runs off with their phone, we have the right to use reasonable amount of force to try to get the phone back. Now, you still don't want to use any force if you can avoid it, because then there's no chance an officer can arrest you. But also, let's say self-defense, right? There is a pushing and shoving match going on, and someone's about to hit you, and right as they're about to hit you, you push them away, right? Well, that pushing away is technically an assault That's an unwanted touching. But if your pushing them away was to stop yourself from being imminently assaulted, that gives you a defense of self-defense. And so self-defense is often messed up by the individual asserting it by the way they describe what happened to the police. So let's just jump into that. What is self-defense? I'm stopping you from about hitting me, and it's about to happen, right? I know it's going to happen. You're charging at me, whatever. It's not you, well, she looked really mad and therefore I punched her. No, you can't do that. That's an assault. Shouldn't punch anyone, but obviously you can't do that. He looked really mad and so I was afraid, so I hit him with his bat. No, I mean, probably not going to be self-defense unless you can articulate why you thought that look with what other factors was imminently going to lead to your assault. You don't have to wait to get shot, don't get me wrong. But what we don't want to do is, kill our chances of a defense by being inartful in why we felt it necessary to use force. Because if you felt it necessary to use force, protect yourself by saying really clear reasons why. The fists were balled up by the other person. The other person was doing this, whatever it might be. You're going to want to articulate that so you have a better chance. What also isn't self-defense? Retaliation. Retaliation is not self-defense. In other words, well, she pushed me first. The dispute was over, but because she pushed me first, I got mad and I pushed her back later. Okay? That's two assaults. That's not an assault and a self-defense. That's two assaults. Each person assaulted the other. Now, they're only going to arrest one, but so many times what happens is one person gets put hands on first, the other person retaliates in a more serious way, a slap across the face that leaves a mark. Well, the person that started the pushing, if they don't have any, if they don't cause any marks on you, and you retaliate and cause marks on the person who started it, the retaliator is getting arrested, and that is not self-defense. That's just fairness, is what you think, right? Well, if they started it, why am I getting arrested? That's not how the law works. A police officer might make a determination who to arrest based upon their idea of fairness, but really they're supposed to decide who is the primary aggressor. And oftentimes a primary aggressor is not the person who went hands-on or made contact the first time. Tons of times it's not that way. Oftentimes another person goes hands-on and the person retaliates and causes some type of visible injury, cut, a bruise, something like that. The retaliator is getting charged even if they didn't start it. Basically, whoever the officer thinks sort of was the worst person for escalating the situation oftentimes will get arrested. So self-defense is a great defense, but you have to be careful how you talk about it during the situation that's being investigated. And your attorney definitely needs to make sure that they learn from you by using artful questioning about, do you have that defense available or not? Because even if you didn't describe it correctly to the police, there's a lot of English as second language people that end up in this situation where they're not able to describe the situation accurately to the police due to still learning to be more masterful in the English language. In those cases, oftentimes there was self-defense available, but not in the way they told the police, okay? And it's up to us attorneys to try to now sit down and actually calmly figure out what actually happened so we can update our version of the events where appropriate to make it match with a viable defense. We have to tell the truth, but oftentimes the truth does make it match with a viable defense. It just didn't get out there very well to begin with. So what we don't want to do in a domestic violence case that was only rely on the factual parts for the defense, right? We want to try to make the most out of the crisis also. Why do prosecutors drop cases sometimes in domestic violence cases? Well, it's a combination of factors. Maybe there's a factual defense, one side versus the other, two versions. Maybe it's the alleged victim doesn't want it pursued, although it's not up to the victim to make the case get dismissed. It's the government's case, not the victim's. And the third thing is, what has the defendant done, right? If you've watched my channel, you understand this. It's really important. Has the defendant done any educational classes? Have they done anger management? Have they done domestic violence, moral recognition therapy, DVMRT? The more things that a defendant can do to better themselves and learn from their role in this incident, and it could be all their fault, and maybe it is, and maybe it isn't, but they're arrested, and so it's their fault in the eyes of the system at this point. The more that you can do to uh, better yourself in the situation, the more the prosecutor can feel relaxed that they have responded to the case in some way. Um, and now they're more able to hear those factual defenses, and they're more able to listen to the victim's wishes. If you haven't done anything, you give the prosecutor no option but to go for your throat, okay, and to go for a conviction. And again, as a defense attorney, what we're trying to do in a positive way is better our clients' lives and futures while also hopefully trying to avoid a conviction that can ruin their futures, right? That's what we do. So these are some of the best defenses to a domestic violence case, and it applies to a lot of different cases. It didn't happen that way, or it was self-defense. I think those are the three categories. Do some classes, listen to your attorney, and hopefully we'll never be in this situation again. So if you found this useful, please like and please subscribe. More people get the help they need. More importantly, if you have a domestic violence case in most parts of Washington State, we will handle cases. Feel free to give my office a call. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.